We begin tonight with the most important story of the night, which is now the complete collapse of judicial ethics at the United States Supreme Court in the person of the most publicly corrupted Supreme Court justice in history, Justice Clarence Thomas. A Supreme Court justice violated the law in plain sight today. And the degradation of the Supreme Court in the Trump era is so complete and has so fully infected most of the news media that what Clarence Thomas did today is mostly being reported as just another day at the Supreme Court. Harvard Law professor Laurence Tribe, who himself is one of the most accomplished Supreme Court practitioners in history, stated the case against Clarence Thomas plainly today, saying Justice Thomas violated 28 U.S.C. 455, requiring any justice to recuse when his or her impartiality might reasonably be questioned, or his or her spouse is known by the justice to have an interest that could be substantially affected by the outcome. Because the only federal judges who are not covered by the Judicial Code of Ethics are the 9 members of the United States Supreme Court, it is commonly assumed that it is completely up to a Supreme Court justice whether to recuse from a case. But there is a federal law, as Professor Tribe pointed out, that does require the recusal of a Supreme Court justice when a spouse is known to have an interest in the outcome of a case. We all know that Clarence Thomas's spouse has an interest in the outcome of the criminal investigation of Donald Trump in Georgia by Fulton County District Attorney Fani Willis. Many Trump associates have fought subpoenas issued by the Fulton County grand jury, and they have lost those fights and been forced to testify to that grand jury, including Trump's election lawyer, Rudy Giuliani, who has already testified to that grand jury. Senator Lindsey Graham is fighting his subpoena to that grand jury, and he has lost his argument in the first 2 stages of the federal case that he brought to try to block that subpoena. A federal district court ruled against Lindsey Graham, and then a 3-judge panel of the 11th Circuit Court of Appeals unanimously ruled against Lindsey Graham, and 2 of those 3 judges unanimously ruling against Lindsey Graham were Trump appointees to the appeals court. And then on Friday, Lindsey Graham filed an emergency appeal to the United States Supreme Court, knowing that the Supreme Court justice assigned to handle emergency appeals from the 11th Circuit is Clarence Thomas. Clarence Thomas should have immediately recused himself from that case, but he did not. And instead, today, Clarence Thomas became the first federal judge in this case to rule in favor of Senator Lindsey Graham, knowing that Senator Lindsey Graham's testimony to the grand jury could include possible questions about Clarence Thomas's wife. It would be reasonable to ask Lindsey Graham who he communicated with about the results of the 2020 presidential election. In court filings, Fani Willis has made it clear she wants to ask Lindsey Graham about his phone calls to Georgia's Secretary of State, asking him about the presidential election in Georgia. It is reasonable to ask Lindsey Graham whether he spoke to Donald Trump before or after Donald Trump's call to Georgia's Secretary of State, the phone call heard around the world.
All I want to do is this. I just want to find 11,780 votes, which is one more than we have.
One of the people who was listening in on the Trump side of that phone call was a Washington lawyer named Cleta Mitchell. Cleta Mitchell is one of the people who Clarence Thomas's wife mentioned to Trump White House Chief of Staff Mark Meadows in her repeated texts to Mark Meadows about trying to overturn the results of the presidential election. Cleta Mitchell is a witness and a potential witness in the Georgia investigation that Lindsey Graham has now brought to the Supreme Court. A Supreme Court justice's wife was throwing around that name, Cleta Mitchell, in her texts to the White House Chief of Staff. And that Supreme Court justice doesn't think that that gives his wife an interest, a legal interest, in the case that the Supreme Court justice decided to rule on today. Clarence Thomas granted Lindsey Graham's request to block his testimony, temporarily at least, block his testimony to the grand jury until his full appeal can be heard by the Supreme Court. And it gets worse. The lawyer who filed Lindsey Graham's appeal to the Supreme Court put two of the justices currently serving on the court in their current jobs. Lindsey Graham's lawyer representing him now at the Supreme Court is the first Trump White House counsel, Don McGahn, who ran the process that chose Donald Trump's first two Supreme Court justices, Neil Gorsuch and Brett Kavanaugh. Those two Supreme Court justices owe Don McGahn their jobs. They should be recusing themselves from this case, too. Now, most judges can overcome these apparent conflicts of interest in the application of law, and that might happen in this case. The Supreme Court might ultimately rule against Lindsey Graham. Clarence Thomas might ultimately rule against Lindsey Graham. But that doesn't change the fact that Clarence Thomas has violated a perfectly reasonable law by participating in this case, a case in which his spouse, quote, is known by the justice to have an interest that could be substantially affected by the outcome. By not recusing in this case, no matter how the case turns out, Clarence Thomas has disgraced himself and the United States Supreme Court once again. Remember, the issue of recusal is not about the judge's actual and real inability to be fair. The issue of recusal turns on our perception, a reasonable person's perception of a judge's potential conflict of interest. And this is full of that for three justices of the current Supreme Court, all of whom should be recused in this case, and none of whom will recuse in this case, not on the Trump Supreme Court. In the other criminal investigation targeting Donald Trump, the New York Times is reporting tonight that prosecutors are focusing on two witnesses, one of whom who was seen on video actually moving boxes of documents at Donald Trump's Florida residence himself. The Times reports security camera footage obtained by investigators showed Walt Nauta moving boxes out of a storage area at Mar-a-Lago, raising the questions about whether they were moved at Mr. Trump's behest to conceal them from the authorities or Mr. Trump's own lawyers, who were dealing with demands that he return the documents. Prosecutors have indicated they are skeptical of an initial account Mr. Nauta gave investigators about moving documents stored at Mar-a-Lago and are using the specter of charges against him for misleading investigators to persuade him to sit again for questioning, according to two people briefed on the matter. The other witness under pressure from federal investigators is Kash Patel, who was officially designated by Donald Trump just this year as one of his official representatives in dealing with presidential records. The Times reports, quote, Mr. Patel refused to answer many questions this month before a grand jury in Washington hearing evidence about Mr. Trump's handling of the documents, citing his Fifth Amendment right against self-incrimination, according to a person briefed on the matter. The Washington Post has reported more about the contents of the documents in the investigation. At least one of the documents seized by the FBI describes Iran's missile program, according to these people who spoke on the condition of anonymity to describe an ongoing investigation. Other documents described highly sensitive intelligence work aimed at China, they said. Unauthorized disclosures of specific information in the documents would pose multiple risks, experts say. People aiding U.S. intelligence efforts could be endangered and collection methods could be compromised.